Could you explain this word to word? I'm reading the line. A company is a holding company in relation to one or more other companies, means a company of which such companies are subsidiary companies.
Alright, let's take it piece by piece. A company just means any incorporated entity. Is just means it's treated as. A holding company is the one with control. In relation to means with respect to, so it's comparative. One or more other companies just allows for one or many. Means is definitional. A company of which just ties back whose those companies are, subsidiary companies. So the full sense is, if a company controls one or more other companies, it's the holding company, and those controlled ones are its subsidiaries.
So a company is a holding company in relation to one or more other companies, means a company of which such companies are subsidiaries company.
Exactly that. Plainly, if it controls them, it's the holding company, and the other companies it controls are subsidiaries. The in relation to part just reminds you it's a link between those specific companies. Does that sit right?
Now, for the purpose of this clause, the expression of company includes any body corporate.
That means company here isn't limited to companies incorporated under the Companies Act. It also covers any body corporate, meaning any entity with separate legal status.
Whereas Section 287 defines subsidiary company in relation to any other company. That is to say, the holding company means a company in which the holding company controls the composition of the board of directors or exercises or controls more than one half of the total voting power, either at its own or together with one or more of its subsidiary companies.
One moment. Right, so in relation to any other company means you judge subsidiary status by comparing it to that other company, which is the holding company. A company is a subsidiary if the holding company, either alone or together with its existing subsidiaries, either 1. Controls the composition of that company's board of directors, or 2. Controls more than half of the total voting power. So even if the holding company doesn't directly hold over 50% by itself, it can add the voting power of its subsidiaries, and if together they cross that halfway mark, the other company is still a subsidiary.
Okay, so let's just dive right into this. I want you to go ahead and close your eyes for a second. Seriously, try it. Picture reality. Think about the physical room you're in, the passage of time, the sequence of human history, all those absolute facts you learned back in biology class. You got it? Good. Now I want you to completely forget it, because practically everything you just imagined, everything you just assume is fixed and true is, well, probably wrong. Welcome to The Explainer. Today, we are taking a sledgehammer to some of our most basic assumptions. We're going to explore how our daily perception of time, the actual timeline of human history, our own biology, and even the universe itself might just be one.
Am I audible?
Yeah, I can hear you fine, but that sounded like a script, not company law. Did you want me to switch gears and respond to that instead?
No, that was a mistake. Don't worry, just ignore.
Got it. Ignoring that. Ready when you are to continue with
So for the
section
purpose
2,
of this
7.
clause, the expression company includes any body corporate, whereas section 287 defines subsidiary company in relation to any other company, that is to say, the holding company means a company in which the holding company controls the composition of the board of directors.
Right. That part is one of the alternate tests. If the parent controls the composition of the board.
When they say where they define subsidiary company in relation to holding company, means a company. When they say subsidiary company in relation to holding company, what does it mean?
It just means you're comparing the two. So the subsidiary status exists only with respect to that holding company. It's a relationship label, not a standalone status.
Means a company in which the holding company controls in relation to the holding means company in
Yes.
which the holding company controls the composition of the board of directors.
Yeah, so if the parent can appoint or remove a majority of the board of directors, that control by itself is enough to make it a subsidiary, even without looking at share percentage.
Exercises or controls more than one half of the total voting power either at its own or together with one or more of its subsidiary companies.
Exactly. Here, exercises or controls is about voting rights. More than one half means over 50%, and either at its own or together with one or more of its subsidiary companies means you add up the voting power held by the parent plus what its subsidiaries hold. If that combined voting power is over 50%, the other company is treated as a subsidiary.
Provided that such class or classes of holding companies as may be prescribed shall not layers of subsidiaries beyond such numbers as may be prescribed.
One moment. That's saying that, however, for certain categories of holding companies, the law puts a cap on how many layers of subsidiaries they can have. The exact number of permitted layers is whatever the government prescribes.
Provided that such class or classes of holding companies as may be prescribed shall not have layers of subsidiaries beyond such numbers as may be. What does it mean? Explain. Word to word in easy words.
Right. So provided that means, but with this condition. Such class or classes of holding companies means certain categories of holding companies. As may be prescribed means as the government specifies by rules. Shall not have layers of subsidiaries means they cannot stack too many tiers of subsidiaries. Beyond such numbers as may be prescribed means not more than the number set in those rules. Simple version. For certain types of holding companies, the law sets a maximum number of subsidiary layers they can have. And the exact cap is whatever the rules specify.
So, for the purpose of this section, a company shall be deemed to be a subsidiary company of the holding company, even if the control referred to in subclause or subclause 2 as of is of another subsidiary company.
One moment. Sure. For the purpose of this section means just for applying the section. Shall be deemed to be means will be treated as. So a company counts as a subsidiary of the holding company even if the actual control in subclause 1 or subclause 2 is exercised through another subsidiary. In simple terms, indirect control still counts. If your subsidiary controls another company, that other company is also treated as your subsidiary.
So, for the purpose of this section, a company shall be deemed to be a subsidiary company of the holding company, even if the control referred to in subclause 1 or subclause 2 is of another subsidiary company of the holding company. So, I have no idea about this subclause 1 or subclause 2. So could you please give me an idea, and also once you explained it word to word, give me an example as well.
One moment. Of course. So the subclauses refer back to the two tests we just talked about. Subclause 1 is controlling the board composition. Subclause 2 is holding over half the voting power. This sentence says that even if that control is not held directly by the holding company, but by one of its own subsidiaries, the end result is the same. The company is still treated as a subsidiary of the holding company. For example, suppose Company A is the holding company. Company A owns 70% of Company B. Company B owns 60% of Company C. Even though Company A doesn't directly own Company C, the law treats Company C as a subsidiary of Company A, because A controls C through B. That's indirect control. So anytime control flows down through a subsidiary, the top company is still treated as the holding company of that lower tier company. Keep that example in mind. A controls B, B controls C, therefore A controls C indirectly.
So as I understood the example, let me read the statement again. So,
Sure,
to-
go ahead.
So a company shall be deemed to be a subsidiary company of the holding company, even if the control referred to in subclause 1 or subclause 2 is of another subsidiary company of the holding company.
Right, so read that as even if the control is indirect. So if your subsidiary holds the board control or the voting majority in another company, that other company is still treated as your subsidiary too. In exam terms, bottom line, indirect control through a subsidiary still makes the lower company a subsidiary of the top holding company.
The composition of a company's board of directors shall be deemed to be controlled by another company if that other company, by exercise of some power exercisable by it at its discretion, can appoint or remove all the majority of the directors.
One moment. Here's the word-by-word gist. as public. Put simply, on paper it stays private, but legally for compliance it is treated as a public company. That's the exam takeaway.
So I didn't get it. Could you explain it again?
Sure. If a private company becomes a subsidiary of a public company, then even if its own articles still call it private, for the purposes of the Companies Act, it's treated as a public company. In short, still private on paper, treated as public by law.
I got it. Now next is associate company. In relation to another company means a company in which that other company has a significant influence but which is not a subsidiary company of the company having such influence and includes a joint venture company. Explanation for the purpose. Now could you please explain me up to this much?
One moment. Sure. So, in relation to another company just sets the comparison. An associate company is one where the other company has significant influence, but not control. So it's not a subsidiary. The company having that influence is the one being
Can
referred
you
to
repeat it again?
and includes a joint. Sure. Simply, an associate company is where another company has significant influence, but not control. So it's not a subsidiary. And a joint venture company is also treated as an associate.
So in relation to another company means a company in which the other company has a significant influence, but which is not a subsidiary uh, comes and includes a joint venture.
Right. Significant influence, but not included. That's spot on.
Explanation of the expression at least 20% of total voting power or decisions under an agreement.
Means either controlling at least 20% of the voting power or the right
20% decisions under an agreement. And this is a control of or
it means that by contract you have a say. Here the law treats significant influence as either having at least 20% of the vote is decision. So even without majority control, those rights can create.
initially you told that influence is not control, but now you're saying
Right, I see the confusion. To avoid the clash, read it as a 20% voting threshold or contract non-subsidiary level control. A subsidiary needs control, like majority voting power or board control.
expression of joint venture means a joint agreement whereby the parties to the net assets of the arrangements. let me read the previous one again. The expression 20% of voting power and or control of or participation in control of.
Right. So it gives two roots. Either you hold at least 20% of the voting power, or you have an either one is enough for significant influence. And that's what makes it an associate significant influence, not full control.
In relation to another company means a company in which company other company have been such influence and includes a joint venture company.
That votes or decision rights, but not enough for a subsidiary. And a joint venture is also included. That's not control.
So on the basis of access to capital, listed company, as per the definition given in 2020, it is a company which has any of its securities listed on any recognized stock exchange.
One moment. 52 of the Companies Act 2013 is the source. Is a company which has any of its securities, so any type like shares or debentures, listed means traded on any recognized stock exchange, meaning an exchange officially recognized under law. So simply, if any of a company's securities are listed on a recognized exchange, it's a listed company.
So to consider significant influence means the control or at least 20% of the total voting power or control or of participation. First is the at least 20% of total voting power, and the other is control of or participation in business decision under an agreement. When they say or control of or participation in business decision under an agreement, what do they mean? Could you answer to that question? Hello?
Hello? What's on your mind?
When they say I was reading the Companies Act 2013, and I was reading about the associate company under which I read about the expression significant influence means control of at least 20% of total voting power or control of or participation in business decisions under an agreement. Could you give example for both of them to make me understand?
Let me think. Okay, yeah, there are two ways significant influence can exist. First, if Company A owns, say, 25% of Company B's voting shares, that's control of at least 20%
Let's say
of total
20%.
voting power. Yeah. So, secondly, let's say Company A owns only 10%
Is it
of Company B, But
Is it changed or
Yeah.
is it still? Is it changed or is it still 20%?
it is